Welcome, everybody. My name is Lisa Benedetti, and I'm going to be giving a talk today about how to read a case. Just as an initial matter, if you have any questions, given the number of people, it would probably be good to put those questions in chat, though I will not be able to see it. So Alicia, can I nominate you to, find some opportune times to ask questions as they come up or whenever they make sense to ask?
Absolutely.
Excellent. Hold on a second. Let's see. Okay. So we are here to talk about how to read a case. So the basic topics we're going to cover today is just starting off with the anatomy of a typical judicial opinion. We're going to cover standards of review because that's always a very important thing to consider when reading the opinion and when using an opinion as an authority. And we will discuss why all of this is important and what to look for when either using or distinguishing an opinion in motions practice, because that's one thing that anyone who's been to law school knows. We've reviewed a number of cases, but we often what we need in the practice of law is how to use the cases in our motions, in our briefings. So just to start off, I'm going to actually go over some preliminary material that is not part of the opinion, but is important to look at when reviewing the opinion. And that's the stuff at the top that just shows the basic information about the case itself. At the top, you've got the case caption, which will show who the parties are and what the case citation is, when it was decided, what level of court decided it, all that sort of material. And whether there were any changes in the process, like amendments, whether there were any reversals, that sort of thing. There will be a synopsis. Again, this is not part of the opinion. You would never cite the synopsis, but it's a good indication of basically what you're going to find, what basic subjects are going to be covered. The list of holdings, again, this is not part of the opinion. These are not official holdings. These are just summaries of the holdings that are provided generally by either Westlaw or Thomson Reuters when publishing the opinion, and then the information about who attorney-wise was involved in bringing this case on appeal. At the very start of the opinion, you'll have the introduction. It's usually fairly short, only a paragraph or two, maybe only a few sentences, that summarizes the opinion's contents and will tell you whether or not the court affirmed or reversed either the trial court or the appellate court below. It may not give you a full roadmap of what you're going to see, but it'll just give you the very quick Cliff's Notes. Now, I sent around a case called Magana as one that I will use throughout this presentation as an example of what you'll find in a case. And I've clipped out the entire introduction of Magana. You'll see that Justice Sanders was the author of the opinion, and it gives a really quick summary of what the case has decided. And it, as in many cases, gives a holding. It states, "We hold that the trial court appropriately diagnosed Hyundai's willful efforts to frustrate and undermine truthful pretrial discovery efforts by striking its pleadings and rendering an $8 million default judgment, plus reasonable attorney's fees. Now we're going to get back to that later because, you know, it's really easy in cases to look for words like "we hold" or "the holding is" and say, oh, that's the holding of the case. And it is, but it also isn't. Because in a case like this, in a case like Magana, where they are deciding discovery disputes, the holding isn't as much about which way the court ruled. Did the court rule that Hyundai violated the rules of discovery? Did the court rule that striking its pleadings and rendering a default judgment was the appropriate action? I mean, it did decide that, but what's more important to a case like this is why they decided it, because the facts are so important to understanding why the court found that Hyundai violated discovery, why the court found that one of the most extreme punishments, striking its pleadings and rendering default judgment, was the right thing to do. Or at least was not an abuse of discretion for the trial court to do, which is another matter that we will get to as we move forward. The next section would be the facts, which would include both the underlying facts of what brought the litigants into court and the procedural facts of what happened after it was in court, and basically mostly what the attorneys did, but sometimes what the parties did as well. And this is a really useful place to just get a sense of, you know, the tenor of what the court is going to address throughout the opinion, because for example, in the Magana case, I'll go through really quickly the facts and procedural history. You'll find, and I summarized them. I tried to summarize them relative to how much attention was paid by the court in the opinion itself. And you'll see in February of 1997, the plaintiff was involved in a car crash and was injured. And in February of 2000, he filed suit, or his attorney filed suit on his behalf. That's about as much as the court went into regarding the car crash itself. And the rest of the facts section is focused on what happened after the suit was filed, what the parties did, what the attorneys did, what happened in discovery. And that tells you a lot about where the court's going with this. What matters less to, what matters to this, the decision on this opinion is less about why the litigants came into court, but what happened afterwards. So in this case, Magana was alleging that there was a manufacturing defect in the car, specifically in the seat of his car, the 1996 Hyundai Accent. And they requested documents from Hyundai regarding that issue. And initially Hyundai refused. They reworded and limited the scope of Magana's requests, but never sought a protective order. And even though Magana asked for information on other car models with the same or substantially similar seat that his car model had, and Hyundai claimed to turn that over, and Magana asked for records of OSI, which are other similar incidents, and Hyundai responded that there were none. It later, and that's how it went to trial. There were discovery disputes right before, leading up to trial. And that's how it stood, that Hyundai says they turned it all over, and Hyundai said there were no other incidents. It went to trial for reasons not important to this opinion. There was an appeal and a retrial was ordered, and Magana then requested updated discovery, and that process continued for months. And just shortly before trial, the month or two before trial, Hyundai finally, for the first time, when forced to do so by the court, turned over more records showing other similar incidents that had not been turned over before. and showing other seat records from other similar models that had not been turned over before. Now recall, so the initial suit was filed in 2000. The trial was held in 2002. This material wasn't turned over until 3 years later in 2005, a month before trial was supposed to happen in January of 2006. So Magana moved for default judgment, arguing that Hyundai failed to comply with the prior production requests, falsely answered discovery, and that a continuance would only reward Hyundai's willful behavior, that evidence was forever lost due to Hyundai's delay. And in this case, the attorney, who is Paul Stritmatter, had contacted potential witnesses from other similar incidents and found that, you know, memories had changed or memories had been lost, documents had been lost, and never to be recovered because of the passage of time. And that as a result, Magana was substantially prejudiced in preparing for retrial, and that Hyundai should not only be given more time to investigate into this issue, more time would not have fixed this prejudice, and that instead a default judgment should be rendered against Hyundai, and the trial court agreed. And the Court of Appeals reversed, finding that there were discovery violations, but not prejudice enough to warrant the significant sanction of a default judgment. So you can see just from going through the facts and procedural history that what's going to be important to this case is not the underlying case itself, but what happened after it was filed, what happened during the discovery process, and how the entire discovery process, trial and retrial, unfolded. Which gets us to the standard of review. Now, there are many standards of review. I'm not going to go over all of them. I'm going to go over the ones that are particularly relevant to the practice of personal injury, but they basically exist on a continuum, ranging from anywhere from no deference to a significant amount of deference. There are actually some standards of review where there is complete deference, though that does not generally apply in personal injury cases. So in our cases, an example of no deference would be the standard of de novo review. These are generally reserved for questions of law, such as when issues are being decided on summary judgment. So what basically this means is that if a trial court makes a decision that is subject to de novo review, and it goes up on appeal, when the appellate court reviews it or when the Supreme Court reviews it, the Supreme Court will review it anew, giving absolutely no deference whatsoever to how the trial court decided. In the middle, we have some deference, which would be an example being the standard of substantial evidence. You find this often in jury decisions or fact finder decisions where a fact finder's decision will stand unless no substantial evidence supports it. And on the farthest side, we have abuse of discretion, which is more deference. And you generally find these in trial court procedures, procedural decisions, such as the one that happened in Magana. When a decision is subject to abuse of discretion, the intermediate appellate court will only reverse the trial court on a clear abuse of discretion. And if it goes up to the Supreme Court will review it under that same standard. It would give deference to the trial court, not to what the appellate court did. So it's helpful to understand the standard review for a number of reasons. One being, when you're presenting your brief, sometimes in briefs we address the standard of review, and sometimes we don't. Sometimes it's so obvious what the standard review is because these issues come to the court all the time. It's a waste of space to even include it, but it can be helpful to highlight in some cases how carefully a trial court's decision could be scrutinized if the issue went up on appeal, because trial courts never want to be reversed. So which is more likely to happen on, say, a de novo review than it is on an abuse of discretion. So if you can highlight, if you can say, trial court, if you get this decision wrong, if you decide opposite of how I'm suggesting, that is an abuse of discretion. Courts have held it's an abuse of discretion and you will be reversed. That can carry weight with the trial court. But it also can help in terms of assessing the persuasiveness of the opinions that you are using in your briefing. For example, if you have an opinion that says, here's what the trial court did, and what they did not abuse its discretion. That opinion isn't saying the trial court was right, per se. It is saying that the trial court wasn't wrong. But a different trial court presented with the same situation or a similar situation could have just as easily decided the other way. And if that case had gone up on appeal, it's hard to say, the court may have said that was an abuse of discretion, or it may have said, either way you go is right. So an opinion that says a trial court did not abuse its discretion has a little less weight than an opinion that goes through all the facts and says the trial court did abuse its discretion. It helps to define the contours of how far is too far for the court to go. So it's a very powerful tool to be able to present an opinion like that to the trial court and say, look at the facts of this case and look at how the appellate court said that the trial court abused its discretion. If you do the same thing here, you will have abused your discretion and you will be reversed. So in this case, in the Magana case, I clipped out the basically the entire standard of review, which goes into not just the standard itself, but all the what it means, what the standard review means, what the contours are. But basically, for our purposes, it boils down to Magana was decided under an abuse of discretion standard. Now, an abuse of discretion standard, much like many of the standards, are easy to describe. There's a lot of, as you can see here, there's a lot of statements out there saying what it means to abuse the discretion. It's another thing to apply it in a particular situation. So as much as these descriptions can be helpful to say an abuse of discretion involves a decision on untenable grounds or untenable reasons, these statements only get you so far. What's really going to matter is the facts of a particular opinion so that you can say, in this case, this happened, this happened, this happened, this happened, this happened. The trial court did this. Was that an abuse of discretion or not? So the next section we get to is the legal analysis, which is where most of the meat of the opinion is found. It will generally go in the order of, and what will be familiar to people who've been law students, the IRAC, the issue rule analysis and conclusion. If there's one issue, it'll go through this process once and be done probably. If there's multiple issues to address or there's multiple factors, if it's like a 4-factor test, they may go through this issue rule analysis conclusion multiple times, depending on each issue or each factor. But generally the structure will remain the same. And I realize it may seem academic to point this out, but I think it is important because, you know, the structure of the legal analysis and frankly, the structure of an opinion itself is helpful, not just for understanding, you know, how to navigate an opinion and knowing where to look for the information that you're trying to find, but also what is persuasive? How should a brief be structured? Often in a similar manner, because this is what lawyers and this is what judges and clerks are used to reading and reviewing, and it'll make the most sense to them to follow a similar pattern in your writing because they'll understand it, it'll be comfortable to them. And for that reason, it'll be more persuasive. Let's see. So I'm not going to go through the entire legal analysis section of Magana because it is quite long, but I will just point out here, we do have, you know, we start off at the analysis section and we state the rule. Whether the trial court abused its discretion to grant a default judgment against Hyundai as a discovery sanction. And it lays out a number of rules that apply to this decision. And then it goes into the analysis. In this case, it actually goes into the analysis in a three-part test. I've only clipped out the prejudice part of the test. And the reason I've clipped that out is, you know, in this case, it again, much like the fact section, where the focus is in a legal analysis section shows what's important. And in this case, a lot of the focus was on the facts that went into supporting the decision of was this an abuse of discretion or not. Now, in this case, what we had was the trial court made a decision and the Court of Appeals reversed it, saying the trial court was wrong. But the Supreme Court here said, no, the Court of Appeals was wrong. The Court of Appeals argued that Magana could complete his inquiry into other similar incidents if he had more time to do so. But then the Supreme Court goes into all the facts laid out at the evidentiary hearing, you know, well established throughout the discovery process, throughout the evidentiary hearing process, about how inquiry even now into other similar incidents was futile and additional time would not have made a difference. All of this is very important to being able to support a decision where you're not only just asking for sanctions, but you're asking for one of the most extreme sanctions that basically the trial court is going to decide that Hyundai loses without a trial. And then at the bottom, we have the conclusion or outcome, again, much like the introduction, a very short section, usually reiterating the holding, reiterating the decision, and stating whether or not the case is affirmed, meaning the appeal is over, unless it gets appealed to a higher court, which in this case it would not because it was at the Supreme Court, or if it's reversed for further action by the lower court. And you'll also find here who joined in this opinion, which in this case, we have most of the court. It's basically, this is basically showing, you know, when they say it's a 5-4 decision or a 7-2 decision or a 9-0 decision, this is where you find out how many joined with the majority, which 1, 2, 3, 4, 5, 6, so 7. It was a 7 decision, which means this case also involves either concurring or dissenting opinions or both. We will find out. Which, in this case, we have a dissenting opinion by Justice Johnson, joined by Chief Justice Alexander. So that was the 2 who felt that the case should have gone the other way. Now, in our business, a lot of times you won't be citing concurring or dissenting opinions, frankly, in a lot of our just daily motion practice. It won't come up. A case may not even have them, or it might have them, but they're, there's nothing worth citing there. But that doesn't mean that you should ignore them, because occasionally you can find some valuable insights in concurring or dissenting opinions, even if they're not precedential. A concurring or dissenting opinion may point out facts, or may point out other legal analyses that the majority opinion downplayed or frankly simply ignored, which can be a good place to look if you're trying to find a way to take an opinion that you don't like, that doesn't support, that on its face doesn't support the argument that you're trying to make, and finding distinguishing factors. You can find those distinguishing factors in the majority, but you can also find them in the concurring and dissenting opinions. Or if in those occasional cases where you're trying to argue for a change in the law or an expansion of the law, concurring and dissenting opinions can be a really great place to look, because often those can be the more forward-thinking opinions. So ultimately, this is all getting down to, how do we use these in our practice? Because, unlike in law school, where we're reading cases, analyzing cases, talking and debating about cases, we are trying to use the cases here to persuade, to advocate for our clients. And there's no hard and fast rule on the right way to do it, but I just want to go through a few guidelines that I found along the way. First and foremost, opinions can be a really great place to find just generalized rule statements. You'll find in Magana that it lays out in great detail what the discovery standard is. That is great information to include in your rule statements, in your briefing. But don't necessarily feel like you have to use the exact quote or rule statement as it's said in one opinion or another. Sometimes those quotes can be great. Quotes can be very powerful. If you have a quote that supports your position exactly the way you want it to, great. But sometimes tweaking that rule statement is an important tool of advocacy. For example, just even the basic summary judgment standard. Summary judgment is appropriate when there is no genuine issue as to any material fact, and the moving party is entitled to judgment as a matter of law. That's a basic statement. But you can also state it as summary judgment is appropriate only when there is no genuine issue of material fact, and the moving party is entitled to judgment as a matter of law. Just one little change. It's not wrong. It's the same statement, but it's placing the emphasis in a different place. So, you might use one statement if you're trying to argue that summary judgment should be granted, and you'd use the other statement if you're trying to argue that summary judgment should be denied. And that's just one basic example, but frequently you'll find with any rule statements in any opinion, there is a way to focus it towards whichever point you're trying to make. Another thing I look at is, particularly when reading opposing counsel's briefing, is how do they use cases? Because, oftentimes, one of the realities of litigation is, as much as you may want to spend hours and hours combing through every single case on every single issue and taking as much time as you need, you just don't have the time. So where should you focus the attention? Well, in principle, you should read every case that they cite. You should shepherdize every case that they cite. Can you do that? Not always. So my rule of thumb is to focus more on the cases that they focus on more. And I don't mean in terms of briefing itself. You need to drive your bus. You need to focus your briefing where you want it to go. You don't want to be on the defensive. You want to be on the offensive. But in terms of deciding what to review, what to pick apart, which cases require the most attention. If they're just citing a case for a basic rule statement, you're not going to need to focus necessarily on that case unless you find out that it's great for you. You're not going to necessarily need to focus your attention on picking apart that case as you would on a case that they spend 3 pages describing the facts in detail, describing the legal analysis in detail, putting a giant block quote, stating that this situation is analogous to this case, and for that reason, the court should decide in opposing counsel's favor. Those are the kinds of cases where you want to focus your attention and either pick them apart or find where the other cases are that distinguish it or state differently. And that's where it gets us to dealing with either analogous or distinguishing facts of a case. This can be, if you can find it, some of the most powerful arguments, because it's, like I said before, it's one thing to state these grandiose, generalized rule statements, but how does it apply in a case like Magana, where the facts are so important? Where if another attorney hadn't done the work the way that Paul had done the work, that case would have ended up differently. And this is where one term that I learned from law school, from one particular professor in law school, is when cases are actually bucket holdings instead of rules holdings. So I want to go back to the quote unquote holding as it was stated in Magana. We hold that the trial court appropriately diagnosed Hyundai's willful efforts to frustrate and undermine truthful pretrial discovery efforts by striking its pleadings and rendering an $8 million default judgment plus reasonable attorney's fees. How useful is that holding when trying to argue for a particular sanction in your case? Frankly, it's not. This is a bucket case where you have to really dig into the facts and say, the court held this, but why? What were the ingredients that went into this holding? Because you'll find another case that'll say the trial court abused its discretion by striking its pleadings, or the trial court did not abuse its discretion by refusing to strike its pleadings and instead only ordering a continuance. And so when you find these cases, you need to look at the facts of each case and figure out, and from these buckets, based on these facts, it goes into the monetary sanction bucket. From these facts, it goes into the continuance bucket. From this case, it goes into the strike pleadings and default judgment bucket. And there you will find the analogous cases, the distinguishing cases, the contours of what this discovery sanction rule really means. And in your cases, and in shepherdizing your cases or in key citing, depending on whether you're using Westlaw or not, you can often find those analogous opinions, those distinguishing opinions. Opinions can be very helpful places where they themselves will cite cases that say, well, in this case, in this other case, the court decided that it wasn't an abuse of discretion, but our case is different because, So you can often find those nuggets just inside cases or citing these cases later. And then I just want to go back to remembering the standard of review, because again, this can be a very persuasive element. Because like I said before, when an appellate court finds that a trial court abused its discretion, that's going to be more persuasive. You know, because in this case, I mean, I'd like to think that a later court would look at Magana and come to the exact same decision every single time, but you know, another court below could have just as easily said, no, I'm not going to grant default judgment. And that case could have gone up on appeal, and the Court of Appeals could have said, well, we might have decided differently, but we're not going to say it was an abuse of discretion just because we disagree with it. So that's where the standard review can really help to either really bolster your case or to state that you know, when if opposing counsel cites a case that says the trial court did not abuse its discretion, you know, how much help does that really give here? So that's pretty much, that's what I've got to cover. Does anybody have any questions? And if you want to unmute rather than type the questions now, go right ahead.
Lisa, it's Gemma Zanowski, who works with you.
Gemma.
I know, you're not even going to admit to knowing me. Lisa, before I hopped on, did you cover anything about reading or interpreting or using cases that are unpublished per the GR that allows you to use them in certain circumstances?
I did not.
14.1.
Thank you, Dan.
I did not. You know, obviously published cases are more persuasive than unpublished cases. There are the rules about which unpublished cases you can use and to what extent. I mean, you're really better off using the published cases. But if you can find like a really on point, like if it's a really factually specific issue and you just can't find. See, here's the thing I have learned from having done research. Every time I think, oh my God, this issue has to have been decided by an appellate court. There has to be a case that is on point. This is such a simple issue. Never find it. Doesn't exist. There are a lot of issues out there that just haven't gone up on appeal. We just found that with in the motion to compel that we were filing in a case where there's a lot of federal cases on it, but there's practically no Washington cases. The best you can find in Washington are trial court orders. So sometimes you have to, you know, dig into maybe an unpublished case just because there's nothing out there, but I try to avoid them. That's just me. Thank you, Gemma.
You're welcome.
Anyone else? We got time. No? Dan?
Lisa, I don't know why you would think that I would have a comment about anything, but I think you did a very nice job. I am sending this to my daughter, who's a first-year law student, and recommending that she watch it. And I think it's good information. I agreed with everything that you said. I would say one more thing, which, since you solicited it,
I did.
My approach to briefing and particularly appellate briefing is to work very hard to tailor my argument to make it sound like it is the best application of the first principles of the law that guide the prior decisions. So not simply to say, case A held this and case B held that and case C held that, and we sort of fit in there somewhere in this new situation, which apparently has not yet been decided, particularly in the appellate courts. I agree with Lisa, lots of the time, shocking what the appellate courts have not decided. But also to a little bit like science, although law, like economics, is both a science and an art, but to try to convince the court that the best explanation, not only for holding in your favor in your case, but also for the law in general, as a matter of general application, this is the best holding, this is the best decision to rule in my favor. And there are a number of ways to approach that. One is to convince the court that the legislature has a particular role and that this court holding will comport with the legislative intent if there's a statute at issue, which much of the time there is. And another is to look at sort of what kind of fact patterns have been driving decisions one way or another, and to place your case within that particular fact pattern. So when this CLE is about reading cases, how to read them, my suggestion is really more about how to apply them. But when you read one case and you get very excited that it's got some phrase in it that you think is going to help you as an advocate, it's important to put that phrase in context, to read the cases around that case, the cases it cites, the cases that have cited it. And I agree with Lisa, it's impossible these days, given the volume of information that comes out almost every day from the courts around our country, state and federal, to keep up with and to fully brief and review every case. But nevertheless, it's always important to, particularly when you're in an area of law that you may not be thoroughly familiar with, and one that you know may be evolving, to read the surrounding cases as well as the case itself. And
you could do an entire talk just about the various approaches, because every approach to briefing is different depending on what issues you are addressing. Or is it a constitutional issue? Is it a statutory issue? Is it an issue about the court rules? Each one requires its own unique approach. So there's no one cookie cutter way of dealing with each one.
That's absolutely right. And my only overarching point was that when you read a case, bear in mind that it is one piece of a bigger whole that you need to fully appreciate before you take that case and try to apply it in a way that might be out of context, because that's not going to help you. So
I'll say I had two thoughts. While one of them, when you mentioned sending it to someone else, this is not an explanation of necessarily how to read a case for law school. When you read a case for law school, you should read everything and be prepared to talk about everything, because in law school, it's not as much about applying it as it is about debating and analyzing and discussing and whatnot. So that's a bit of and in that way, reading cases in law school doesn't fully prepare you for actually using the cases in practice. But I do also want to mention, as far as briefing is concerned, and this isn't necessarily about how to read a case, but I think it's important to mention, and I touched on it earlier, when you're briefing for motions practice, when you're responding to opposing counsel in particular, it can be very easy to fall into the trap of being on the defensive, responding directly to their arguments And usually as a result of doing that, you end up missing certain points and also looking like you're on the defensive and therefore looking like you're losing, even if you have the stronger argument. And yes, you do need to at some point pick apart the points that they are making. And that's where reading the cases and understanding them and distinguishing them is important. But you need to draft your briefing the way you want to make your argument. And then secondarily worry about, what the defense is saying and how to attack that.
Sorry to butt in here again, Lisa. I totally agree with you. Nevertheless, based on my experience, I would say that it's a mistake to completely ignore important cases cited by the opposing side, which I know you're not recommending that anyone do, but it is something that I have seen lawyers do. It's extraordinarily frustrating for judges, and the last thing you want to do is frustrate a judge. You want to be the authority who convinces the judge that you're right, and that requires sometimes, unfortunately, having to distinguish cases that get thrown at you, sometimes by opposing counsel, throw everything against the wall that they think is going to stick and makes the job difficult, particularly within a page limitation. You can find ways to do it.
All I'm saying is, rather than start out by saying why the moving party is wrong, you start off by saying why you are right. And number two is why they are wrong. And that way you're framing it more powerfully. That was it. So unless anybody has any other questions or thoughts, I think we'll call it. Thank you very much for coming, and keep an eye out. I'm sure we'll be doing other series on other issues. I will in this moment volunteer Dan to do the next one on evaluating legislative intent. Sure, that sounds good.
Thanks very much, Lisa. Well done.
I'll take it under advisement.
Thanks, Lisa. Great job.
Thank you, Lisa.
Thank you, Lisa. Great job.
Thank you.